We now go to the third mode of extinguishing an obligation, which is condonation or remission. And I think I mentioned to you yesterday, by virtue of a special law, remittances, failure to remit your SSS contribution, there is a law condoning penalty being imposed, and that is only effective up to July of this year. So that is what? If you will notice, it is in accordance with the provision of the Civil Code. Now, since condonation or remission is gratuitous, it is an act of liberality. Therefore, it has to comply with the formalities of a donation. And what are the formalities of a donation? Remember that the formalities of a donation will be dependent upon the kind of object or property being donated. If the property is real property or personal property. If it is personal property, which means movable property, if the value does not exceed 5,000 pesos, it need not be in writing, but it only requires simultaneous delivery. And of course, acceptance on the part of the recipient, the donee. But if it exceeds 5,000, then it has to be in writing with the acknowledgement of acceptance on the part of the donee. If it is a real property, it is not only in writing, but it has to be a public instrument. And take note, this formal requirement is necessary for the validity, not enforceability. So when we go to the different kinds of contracts, it will not fall under the statute of fraud. Okay? And this afternoon, when we talk about the different kinds of contracts based on perfection, a donation is an example of a formal or solemn contract. Why? Because non-compliance with the formal requirement, if it is a real property of being reduced into a public instrument, it will make the donation void. Non-compliance of reducing it into writing, if it is a personal property, the value exceeds 5,000, it will make the donation void. Okay? And take note of the requisites for that condonation or remission to be valid. It has to be gratuitous, which means no consideration is given. It has to be accepted by the obligor. So that means the obligor is the donee. Okay? And the obligation is due and demandable. Because you cannot condone an obligation that is not yet due and demandable. So if all of these requirements are present, then the condonation or remission will be considered as valid and will extinguish the obligation. Although class, take note that the condonation or remission may be total or it may also be partial. And if you remember yesterday when we were talking about plurality of obligations, if it is a solidary obligation or it is a joint obligation, isn't it? We said that if it is a total remission or condonation, it benefits everybody. But if it is a partial condonation, then it will simply be, the principal obligation will be reduced, but then that will also still be spread out among the solidary debtors. What about if it is a joint obligation? Considering that in a joint obligation, every debtor will only be liable to his corresponding share. So if his share is the only one that is condoned, it will not have any effect to the other co-joint debtors. Okay? Confusion or merger. Class, take note, in property, you encounter the word confusion. So do not be confused if you will be asked to define what is confusion in the bar exam. Because in property, confusion is what? It is an accession involving a personal property. Diba? Which refers to two liquids. Diba? Natandaan nyo? Confusion, conmiction. Ang conmiction, two solids. Ito is the second definition of confusion if taken in the context of obligation. Confusion is merger of the personalities of the creditor and debtor into one person. Now, kahit na anong libro sa OBLICON ang basahin nyo, lahat ng commentators, iisa lang ang example, di ba? Bayad ng in the form of check. Tapos, dahil nga it is a negotiable instrument, pinasa kay B, si B pinasa kay C, si C pinasa kay A. Therefore, there is confusion or merger. But take note of the requisites. The merger of the characters of the creditor and debtor in the same person. So it can be in the person of the debtor or in the person of the creditor. Okay? It must take place in the person of the principal creditor or in the principal debtor. And it must be complete and definite. So in other words, if in remission there is partial remission, there is no such thing as a partial confusion or partial merger. It has to be definite and complete. For it to be a valid mode of extinguishing an obligation. And another thing that has to be noted, in relation to a joint obligation, confusion does not apply. At least remission it applies, di ba? Na ano natin kanina. But in joint obligation, it will not apply. Why? Because how can it be applicable to a joint obligation if the debtor is simply liable to his corresponding share? What happens to the share of the other co-joint debtors? Okay? Bukod sa payment, among the modes of extinguishing an obligation, this is another mode that is usually being asked in the bar exam. Especially the so-called legal compensation. So whether you like it or not, you have to memorize what are the requisites of legal compensation. In layman's term, as I always ask my students, compensation simply means what? Quits. Quits tayo, ha? May utang ako sa'yo, may utang ka sa'kin. So, kesa magkaliwaan tayo, wag na tayo magbigayan, basta quits na lang tayo. Okay, so we now enumerate, ano ba yung aking code? Ang code ko dito, Primo DLS. Primo. Ano si principal debtor or and principal creditor. Ano si money. Yung D, ano yung D? Yun yung debts are due. Word is due. Ano yung L? It has to be liquidated. And S, neither subject to retention or controversy. So again, ano ang ating requisites for legal compensation? Ang code natin, Primo DLS. Pre, referring to principal debtors and creditors of each other. Both are principal debtors and creditors of each other. Ano si mo? Debts are sum of money or if consumable are of the same kind and quality. So the mode refers to money. Both debts are sum of money or if consumable, same kind and quality. Ano si D? D means due. Both debts are due. Ano yung L? Debts are liquidated. What do you mean by liquidated? It is determined and certain. You might ask, Ma'am, if it is an obligation which is in the form of money, is it not liquidated? It depends because if, for example, there is an agreement that there is a penalty or an interest to be imposed, unless and until you have computed the interest and the penalty, it is not yet liquidated. Because to be liquidated, definite na siya. Determined, certain. That is the meaning of liquidated. Kasi di ba minsan nilalagay na penalty, for every delay, there is a penalty of 0.01% of the principal obligation. So, paano masasabing liquidated yon? Magko-compute ka muna. Pag certain na, yun na siya liquidated. Okay? not subject to retention or controversy. So that means there is no other third person who has an interest over it. So if all of this are present, class, even if the creditor and debtor are not aware of it, by operation of law, the obligations are extinguished. So kung titingnan mo dito sa compensation, hindi lang isang obligation ang nag-extinguish. Dalawa. Kasi nga, quits na kayo. Diba? And be very careful. Bakit? Take note of the qualifying term principal. I can be a debtor, but my liability is not principal but only accessory. And when is that possible? If I'm simply acting as a co-guarantor. Okay? Now, when it comes to no problem regarding money, but when you talk about consumable, that's why I already inserted the word fungible. A fungible property, it refers to a property that can be what? You can replace it by another property of the same kind and quality. So, pag itong tubig, okay, merong kumuha, so that it can be considered dapat ang ibabalik ganito pa rin. Now, both debts are due. Ano yung posibleng ano? Kasi, ang problema dito, bibigyan kayo ng facts. So, what you do, class, do not forget primo DLS and then immediately identify principal debtors and principal creditors bisala sa isa-isa. By enumeration, elimination, isa-isahin mo na. So, you know what I suggest? If the code that I am giving you will help you, immediately you write it in your questionnaire. Tapos, basahin mo ngayon yung kwento and then i-apply mo by elimination. Kasi pag lahat ng requirements na yon ay present, tsaka mo lang masasagot yung tanong, is there a legal compensation? The absence of one of these requisites will not give rise to a valid legal compensation that can extinguish the obligation. Although, class, this legal compensation, because there's another kind of compensation, the conventional compensation. When you say conventional, it's based on the agreement of the parties. So if it is based on the agreement of the parties, it need not follow these requirements. Now, there's also such a thing as a judicial compensation. Okay, so when you say judicial compensation, definitely it has to be in court, and it involves what? It involves a case wherein there is another case involving the same parties, and damages were awarded, in which case you have to call the attention of the court and inform that judicial compensation can take place. But this kind of legal compensation, it is immaterial whether the parties involved are aware of it or not, because it is by operation of law that the obligation is extinguished. Now, can there be compensation in all cases? No. There are cases wherein compensation is prohibited. And if you will be asked in the bar exam, enumerate when is compensation prohibited. Number 1, if it is an obligation arising from a deposit. Because remember, class, deposit may be gratuitous or onerous. Diba? What is deposit? It is a contract wherein you deliver possession over the property for safekeeping. What is another contract wherein compensation is prohibited? Obligation arising from comodatum. Bakit din prohibited? Because in comodatum, just like in deposit, there is no transfer of ownership because, as I've said, in deposit, it is simply for safekeeping. In comodatum, what is transferred is simply use and possession over the property. And the bailee has the obligation to deliver or return the same property that was handed to him for use. That's why it cannot be subject to compensation. Because you have to return the same property which is given to you for use. You do not acquire ownership over it. Any other case wherein support of compensation is prohibited, support by gratuitous title. Pwede ba yon? Halimbawa, hindi ka nabigyan ng support ng tatay mo, okay? Tapos, ang nangyari is, binili mo yung property ng tatay mo. Pwede ba sabihin mo sa tatay mo, tay, quits na lang tayo. Hindi mo ako sinuportahan ngayon. So, binili ko tong property mo, hindi ko na lang babayaran. Hindi po pwede. Because compensation is prohibited. If it involves support by gratuitous title. Compensation is also prohibited if it involves a civil liability arising from a criminal offense or a delict. Why? Because it will create an impression that delict is something that is what? Subject to settlement, di ba? And you know very well in criminal law, there can be no amicable settlement in case of a delict. Another one, damage caused to the partnership by a partner. This one is explicitly provided by law. Compensation is prohibited. So if the partnership has an obligation to that partner and the partner has an obligation to the partnership, there can be no compensation. And obviously, there is no compensation when it comes to your obligation in favor of the government. So kung halimbawa, nagkaroon ng exercise of the power of eminent domain that involves your property, although you are entitled to just compensation, but at the same time, since you have an obligation to pay your income tax, you cannot tell the government, I will not anymore pay my income tax, i-offset na lang natin yung bayad nyo ng just compensation sa akin. Because remember, every agency has its own, own fund for its own purpose, for its own use. So even if the government as a whole or the state is indebted to you for just compensation and you're indebted to the state because of your income tax, you cannot apply compensation. Otherwise, it will be difficult to know to what agency you're going to coordinate. Okay? Is it possible that the creditor can still assign his interest to a third person? And still, there can be compensation. Di ba, minsan nakakita na nakagawa na iba sa inyo yung deed of assignment over a right. So, here is a creditor assigning his credit to a third person. What will be the effect? Can there still be compensation? Now, class, I would like you to remember that 1285 contemplates 3 cases when it comes to the assignment of credit by the creditor to a third person. First case, the assignment of credit to a third person was with the consent of the debtor. So, pumayag yung debtor na instead na sa akin magbayad, sa'yo na lang kasi inassign ko yung aking credit sa'yo. There was consent on the part of the debtor. Yung second case, ayaw pumayag ng debtor for the assignment. Debtor would still insist, hindi, dapat ikaw lang kausap ko. Hindi mo po pwedeng ibigay yung right mo, yan key 1. And third case, nag-assign yung creditor, inassign ng creditor yung credit niya sa third person nang walang kaalam-alam ang debtor. Now, if you will read 1285, it will tell you that the creditor still has the right to assign his credit to a third person. But of course, the assignment of his credit will have a different effect depending upon whether there was consent, no consent, or it was done without the knowledge of the debtor. Okay? So we go first to the first case. There was consent on the part of the debtor allowing creditor to assign his credit. So, paano na ngayon yung compensation? Here, the code says, debtor cannot set up compensation unless he reserves the right at the time he gave his consent. So, class, this contemplates a situation, ako may utang sa'yo, ikaw may utang sa'kin. Okay? So, dapat, kung lahat yung primo DLS nandoon, magkakaroon ng legal compensation, di ba? By operation of law. Pero, Ang gusto mo, yung credit mo, ibibigay mo sa kanya. Pwede ko pa ba rin sabihin, hindi, may compensation, mag-a-apply pa rin para hindi na ako magbibigay ng, hindi na kita babayaran. What does the law say? Okay. If there is consent, compensation will not anymore be applicable. Ibig sabihin, pag siya na ngayon ang kaharap ko, hindi ko na po pwedeng sabihin, hindi, offset na natin. Kasi alam ko naman binigay lang sa'yo yung credit niya. Diba? Parehong, kumbaga, yung utang natin sa isa't isa, instead na magbayad ka sa akin at ako magbabayad sa'yo, ang nangyari, yung personality mo, yung right mo, binigay mo sa kanya. So, dapat sa ating dalawa, nag-work originally yung compensation. So, dahil iba na ngayon ang kausap ko, pwede ko pa rin bang i-insist, hindi, may compensation. What does the law say? For as long as there is reservation on the part of the debtor that he can still apply compensation, then even if the credit has already been assigned to a third person, compensation will take place. But if debtor fails to reserve that right to avail of that compensation, considering that he consented, pumayag siya, transfer niya yung credit niya dito kay 1, then I cannot anymore raise the defense of compensation. I can only raise it if I made a reservation. Yung number 2, I did not give my consent. Kahit na pinagpaalam mo sa akin, hindi, bibigay ko na yung credit ko sa kanya. So, kayo ng dalawa mag-usap. Hindi ako pumayag. Now, dahil hindi ako pumayag, compensation will be applicable to those that were due prior to the assignment. Pero yun na yung mga later on nang mag-due after the assignment, compensation will not anymore be applicable. Debtor can set up compensation previous to assignment, referring to previous debts that are due prior to the assignment. Okay? And finally, in number 3, inassign mo sa kanya yung credit mo. Hindi ko alam. Kailan lang po pwedeng maging binding sa akin yung assignment na yon? Pag nalaman ko na. So hanggat hindi ko nalalaman, po pwede pa rin mag-apply yung legal compensation. Is that clear? So if you have any question in the bar exam related to the assignment of credit, try to find out under what scenario will it fall. Will it fall under scenario number 1? There is consent on the part of the debtor with respect to the assignment of credit. Or will it fall under number 2? There is no consent on the part of the debtor. Or will it fall under number 3? Assignment of credit made by the creditor was made without the knowledge of the debtor. Because all of these 3 cases, they have different effects to the compensation. Is that clear? So this will be the last mode of extinguishing an obligation. Novation. Take note, novation will take place if any of this will change. Number 1, it can be the object or the principal condition. Number 2, if there is a change in the debtor. Number 3, change in the creditor. So any of the 3, hindi kinakailangang cumulative. Isa lang. Pag nagbago ng object, kaya nga diba when we were talking about dasyon and pago, which is a special mode of payment, most commentators are of the opinion it should be placed under novation. Bakit? Because there is a change in the object. Instead of paying in money, the payment now will be in the form of a property. Kung susuriin ninyo, ang novation, strictly speaking, does not totally extinguish an obligation. Bakit? Because the moment that there is a change, one obligation is terminated, but a new obligation is created. Diba? So, pag nag-change ng object, kagaya sa dasyon and pago, nawalan ka ng obligation to pay a sum of money. But what is created? Obligation to deliver your property as payment for the principal obligation. Ganun din, substitution of debtor. Nawalan ng obligasyon yung first debtor, pero nag-create ng panibagong obligation. But this time, affecting the new debtor who substituted the original debtor. Ganun din when it comes to subrogation by a third person. Nawala yung obligation ng original debtor do sa original creditor, pero yung bagong creditor ngayon, yung third person, dun ka ngayon magkakaroon ng obligation. So one obligation is extinguished, but another one is created. That is in novation. Now, kindly memorize what are the requisites so that novation can be considered as a valid mode of extinguishing one's obligation. So there is an old obligation, and then there is a new obligation. Kaya nga sinasabi ko, hindi siya talaga total extinguishment of an obligation. And then there is a substantial difference between the old and the new obligation. Balik tayo sa dasyon in pago, di ba? Una, pera ang pambayad mo. Yung pangalawa, ang pagbabayad mo property. So, substantially different. And then, of course, capacity of the parties. And finally, which is very, very important, intention to extinguish. Class, novation is not presumed. Novation should be in unequivocal terms. So, if ever in the bar exam, you encounter a problem wherein the question is there a novation? Find out if there is an explicit stipulation that the first obligation is extinguished and the new obligation will substitute. Or the replacement of a third person in lieu of the debtor or in lieu of the creditor will extinguish the obligation of the old debtor as well as the old creditor, because it has to be in unequivocal terms. So, any element here or any requisite here that is missing, your answer should be there is no novation. Okay? So take note, as I mentioned a while ago, extinction of old obligation be declared in unequivocal terms, or old and new obligations are on every point incompatible. So that we can really say that the novation extinguished the obligation. Talagang incompatible sila. Now, the novation can be a real novation or a personal novation. When you say real novation, there is a change in the object, which happened in dasyon in pago, di ba? From money, it is substituted with a property. That is a real novation. Now, if it is a change of party, that is what we call as a personal novation. Now, when it comes to the change of the debtor, or substitution of debtor, there are two kinds. You have expromission and delegation. When you say expromission, it is change of debtor without the knowledge and consent of the debtor. When it says delegation, delegate. So that means it already gives you an idea, delegate, delegate with consent on the part of the debtor. Delegation, with the consent, with the knowledge on the part of the debtor. Now, what is the reason why you have to identify whether the change of the debtor is with the consent of the original debtor or without the consent of the original debtor? Kasi ang problema, papaano kung yung new debtor insolvent? Diba? Pwede bang balikan ng creditor yung old debtor? Now, to be able to answer that, you have to find out whether the change of the debtor is without the consent or with the consent. Because if it is with the consent and the insolvency of the new debtor happens prior to the changing of the debtor. So, kumbaga, itong new debtor na magpapalit sa old debtor, insolvent pala, at saka it is of public knowledge at alam din ng old debtor in case that insolvency will give rise to what? Revival of the obligation of the old debtor. Kasi parang may bad faith kung titignan mo, di ba? Alam na nung old debtor na insolvent pala yung ipapalit niyang debtor, tapos pumayag siya, para lang makawala siya. Kasi di ba, pag nagkaroon ng change, anong obligation ng mag-extinguish? Yung obligation niya. So, sabi ng batas, teka muna, kung insolvent yung bagong debtor, at alam mo na insolvent siya bago magkaroon ng novation, pwedeng maghabol pa rin ang creditor sa'yo. Kasi in bad faith ka, alam mo na ngang insolvent tapos siya pa ipinalit mo. Pero it is different if it is expromission. Pag sinabi nating expromission, nag-change ng debtor yung creditor na hindi alam nung original debtor. So, pag insolvent yung new debtor, at least it is advantageous to the old debtor. Bakit? His obligation will not be revived. So, creditor assumes the risk. He cannot run after anymore against the former old debtor. So, do not forget the distinction between expromission without knowledge and consent on the part of the old debtor and delegación. I think the word delegación can help you easily remember. Pag delegasyon, i-connect mo kagad delegate. Sino nagde-delegate? Di yung old debtor. So, dinelegate yung old debtor sa new debtor. May knowledge yung old debtor. Is that clear?